Hello, my name is Shannon Zollo. I am a corporate partner at Nutter, and I am participating in this webinar together with my partner, Jonathan Calla. We have gathered this morning to discuss the CARES Act and employer funding solutions pertinent to that act. We're on Thursday of the week in which the act effectively will take effect. And in particular, we're going to be talking about the Payment Protection Program, referred to as the PPP. We will also cover some additional potential employer funding solutions for the current crisis resulting from COVID-19. The agenda for today's webinar. Oh, and I apologize. Let me Jonathan, if you wouldn't mind, just go back one slide. I apologize. In addition to myself and Jonathan Calla, one of our colleagues, Natalie Cappellazzo, will also be presenting on labor and employment-related solutions to the extent that companies end up terminating and or furloughing their employees. The agenda for the webinar today will be as follows. We'll first discuss the PPP, referred to as the Paycheck Protection Program. We'll then discuss at a high level the eligibility requirements that are pertinent to that program. And within that context, there has been quite a bit of confusion regarding what are referred to as aggregation requirements, and so we'll address that. Next, in terms of the loan application process, we'll discuss the terms, the use of proceeds, and how the forgiveness portion of the PPP works. After that, we will actually give you some tactical suggestions as to how to approach the application process. It will become effective tomorrow, Friday, April 3rd, and we want to be able to give you some tactical suggestions as to how to initiate the process beginning tomorrow. Next, Natalie will address some of the employment benefits / unemployment benefit related issues that are commensurate with what's happening around us in terms of terminations. And then lastly, we will cover emergency funding options that extend beyond the PPP, and we'll cover those also at a high level and point you in the right direction depending upon your company size and or the particular program that you may be interested in pursuing. My colleague Jonathan Calla and I will rotate back and forth in terms of what's covered throughout the slides, and so at this point I'll turn it over to Jonathan. Jonathan?
Thanks, Shannon, and good morning. I want to first thank everyone for joining us this morning, including the folks up early on the West Coast and those north of the border. It's great having all of you with us this morning. So let's get right to the CARES Act and the Paycheck Protection Program, which was signed into law on Friday. A few highlights to touch on at the outset. A major focus of the legislation is geared towards providing financial assistance to help businesses keep workers on the payroll during the physical and economic shutdown that we find ourselves in. The CARES Act includes a $349 billion Paycheck Protection Program, known as PPP, as we're all getting familiar with that acronym, which will provide guaranteed loans to small businesses. The loans are to be used to cover payroll costs and other operational obligations. We'll touch on a number of those in the next few slides. The PPP loans, as they are called, will be administered through the Small Business Administration. The loans are guaranteed by the SBA, and they may be made by commercial banks, lenders until June 30th, 2020 of this year. The PPP loans may be in an amount up to $10 million, and we'll also touch on the maximum loan amount in the next couple of slides and how to determine that number as it relates to your business. Underwriting standards for the PPP loan eligibility are more relaxed as compared to existing SBA loan programs, with personal guarantees, collateral, and a certification that the borrower cannot obtain credit elsewhere not being required for the purpose of obtaining a PPP loan. So let's get to eligibility. Who is eligible for a PPP loan? Eligible borrowers are going to include any business concern, nonprofit organization, veteran organization, or tribal business that was in business on February 15th, 2020. Also, the business must employ not more than 500 employees. There are some exceptions to this that we'll get into later, but to the extent that the SBA has guidelines that make this number different for your specific business, what we're advising is, understand your NAICS code, which you'll find on your tax returns. And there are certain instances where the 500 employee number goes up or down depending on the sector or industry that your business is in. Note that for the purposes of determining the number of employees, this includes all full-time, part-time employees. Further, based on the SBA regs that we've taken a look at, we would take the position that the employee count is to include any employees obtained from a temporary employee agency or other professional employee organization. Finally, part-time and temporary employees would be counted the same as full-time employees for the purpose of determining the 500 employee number. Eligible borrowers are also going to include sole proprietors, independent contractors, and self-employed individuals. More specifically, this is an avenue of relief for the piano teacher, the Uber driver, the hockey skills instructor who's been impacted by the many shelter-in-place orders that have been put in place around the country. So this is a far-reaching program that's intended to cover small businesses of all sizes under 500 employees. An important note for eligible borrowers in the food, services, and accommodation sectors, which I know there's a few folks on the call in that industry. To the extent that the NAICS code beginning with 72 is found on your tax returns, that's the place you want to take a look for that. The 500 employee limit is applied to each physical location and not the company. So by way of example, a restaurant or hotel with 1,000 employees and 10 locations would be eligible for PPP loans at each applicable location that has less than 500 employees, as opposed to aggregating them all. Shannon will speak to SBA affiliation rules shortly, a key element in determining the employee count for a business, as noted above. But I will note that the affiliation rules with respect to PP loan eligibility are waived for the food and accommodation sectors that we just spoke about. Any entity operating as a franchise, so long as that franchise has an SBA franchisor code, and any entity that receives financial assistance pursuant to the Small Business Investment Act. So that's an important distinction for folks in the food and accommodation sectors to keep in mind as to their eligibility for a PPP loan. So moving forward with the eligibility requirements, again, February 15th, 2020, you want to demonstrate that you had paid employees and payroll taxes and that the business was operational. Further, eligible borrowers will need to make a good faith certification that first, the loan is necessary due to the uncertainty of current economic conditions caused by COVID-19 and is necessary to support borrowers' ongoing operations. Second, the certification will need to acknowledge that the funds will be used to retain workers and to maintain payroll or make mortgage, lease, and utility payments. And third, a certification that the borrower does not have an application pending for another SBA program. Note that when the CARES Act was signed into law on Friday, it was expected that additional guidance would be forthcoming from the SBA. While there has been some initial guidance provided earlier this week, we expect additional guidance to come in the coming days as there are some additional more nuanced points under the CARES Act that folks are bringing forward as it relates to what constitutes payroll costs, what is allowed to be forgiven, and many of those questions are being put forward to folks like us. And given the speed at which this is all moving, it's invariably there's going to be some things that maybe certain circumstances that aren't quite captured in the legislation, and the SBA will be providing guidance on those items in the coming days. So I'll now turn it over to Shannon, who will speak to some of the SBA affiliation rules, an item of much discussion and of particular importance to many listening on the call this morning.
Thanks, Jonathan. So in terms of the affiliation rules, as a general proposition under historical SBA lending, if a company has an employee workforce in excess of 500 employees, it does not qualify for a small business loan, and then would be shifted to other programs for mid-sized companies. The intention of the CARES Act and the PPP in particular is to obviously get as much cash into the small business community nationwide in order to stem the necessity for drastic terminations, furloughs, and things that will have a negative impact on the economy. However, the language of the CARES Act and the eligibility requirements for the PPP are drafted such that it follows the historical pattern of the 500 employee limit. And in addition, under what are referred to as the aggregation rules, the SBA does not want to initiate loans to portfolio companies of either private equity or venture capital firms, professional investors, and companies that are backed by those types of organizations in situations where the employee base of the aggregate of all of the portfolio companies exceeds the 500 employee limit. That was the genesis of the aggregation rules historically, and it has come through in terms of the initial draft of the language of the CARES Act and the PPP. So obviously, for a number of people on this call, if they're working within the private equity or venture capital communities as professional investors, and or we have CEOs and CFOs and COOs of portfolio companies of those types of firms on the call as well, this can be a great challenge in terms of eligibility for the PPP. On first glance, many folks in those communities take the position and assume that they do not qualify. However, our advice to our clients is to dig a little bit deeper and have a better sense of what the aggregation rules mean in their specific situation and within the context of the PPP. So what does that mean specifically? 2 points come to mind. The first is, and now we're broaching on the political aspects of this program, Nancy Pelosi, Speaker of the House, has sent a letter within the last 48 hours or so to the SBA and has suggested strongly that the aggregation rules should not be enforced or should not apply to companies that fall into the categories that were previously discussed because it defeats the underlying intent of the CARES Act. Nothing has officially come out to that extent, but it is not unreasonable to take the position that there could be forthcoming legislation or amendment to the underlying act that clarifies this point. Secondly, there are a number of steps that either PE or VC funds can take, even as minority owners in enterprises, to indicate a lack of control, which is one of the criteria that the SBA would look at in terms of determining whether or not the aggregation rules apply. Does that firm have effective control on some strategic and or operational level of its portfolio companies such that the employee headcount of all of the portfolio companies in question should be aggregated? So I'm going to try to give some advice here in terms of being a PE or a VC fund, and some steps you might take to put yourself in a stronger position to put the portfolio companies that you invest in under the 1,500 employee aggregation limit. And then I'm also going to give some advice to companies that do have investment capital on their balance sheet or in their cap table, and how they may mitigate the need to somehow aggregate themselves with other similarly situated portfolio companies that they are aware of within the same portfolio. On step one, as it relates to the funds, to the extent that the governing documents in a given portfolio's company give you specific rights, what are termed veto rights, or give you governance rights that would be deemed controlling, and some specific examples that come to mind, board control, veto rights on the size and the appointments to a board, the ability to call quorum meetings, or the requirement that you be included in such quorums. Those types of contractual rights that may exist in your governing documents within those portfolio companies can be amended and mitigated, lessened, in order to get you under the definition of control and out of that purview, so that you do limit the amount of aggregation that has to occur for your particular portfolio companies. If you can change those types of contractual rights through an amendment to your charter, file that with the Delaware Secretary of State if that's your state of jurisdiction, and then subsequently apply for the PPP, that would be a strong position to be in down the road, if and when, to the extent that your application or your receipt of funds were ever challenged. Additionally, if you have a series of operational veto rights as a fund within a particular portfolio company, where your right or your vote is required in order to incur a certain amount of debt, third-party debt, or to buy and sell the company, or to make certain types of appointments to management, etc. If those rights also exist from a veto perspective and are more operational than governance, again, an amendment to the charter to lessen those rights would put those types of funds in a stronger position from a defensibility standpoint. Shifting gears to the portfolio company, what are some of the things that you can do to help yourself not be deemed as part of a bigger pie for purposes of the 500 employee limit? Obviously, you can review your existing governing docs to make sure that some of the aforementioned rights are not present. Secondly, to the extent that there are not strong affiliations with your investor base, whether it's professional money or otherwise, and they have a significantly lower percentage ownership threshold within your company, then it's not unreasonable to take the position that those investors do not, quote unquote, control your company, and therefore you're not subject to aggregation. These are just some high-level practical steps that we advise you could consider as part of your pre-application process. All that being said, it's important to note a couple of realistic scenarios that are going to result because of the situation that we currently find ourselves in. The banking community, the commercial banking community, the SBA lenders are going to be inundated with applications beginning tomorrow for the PPP. And they are not, in our judgment, going to do extensive underwriting diligence as part of these application processes because they are not going to have the bandwidth to do so. They're going to rely on the certifications that Jonathan referred to earlier of each of the loan applicants. And to the extent that those loan applicants may have some questions for which they might have a quick answer, they could participate in the application process in that manner. But in our judgment, they are going to be processing more than performing significant underwriting diligence. So to the extent that there are some ambiguous points for which the SBA has not granted additional guidance as to how it should be interpreted for purposes of the application, our recommendation to companies and to funds is to take obviously a defensible position, but as favorable a position as you can as it relates to your particular application. This very well may end up being a situation where It's an event that occurs down the road, if at all, in terms of review of the applications and whether or not companies completely fall within the application guidelines. But there are going to be quite a few applicants that probably are in the quote-unquote gray area. And so our recommendation to those types of applicants is to submit the application, do the best that you can, take favorable positions that are, reasonably defensible if and when they were ever inquired about down the road, and proceed accordingly. The last thing I'll say before passing it back to Jonathan is there may be additional clarification that's forthcoming, and so it does not inure to your benefit to wait for that clarification. Get in the queue with your lender, get your application completed and filed, and then to the extent if and when there's additional clarification, whether it's favorable or unfavorable to you, you have not lost the benefit of time for purposes of the PPP. Although $349 billion sounds like a large number, when you analyze the relevant parties that are going to apply for this, the numbers quickly and exponentially increase such that it's not unreasonable to assume that in the first 3, 4, 5, 6 weeks of the program, the $349 billion could be quickly tapped into, if not exhausted. There is a significant possibility in our judgment that those funds could be supplemented, depending upon how the recession unfolds, but it's not in your best interest to assume that. In order to benefit as quickly as possible from what funds have been already authorized, you need to get into the queue. With that, I'll turn it back to Jonathan.
Thanks, Shannon. So after determining the eligibility, let's quickly walk through some of the loan terms. So let's first talk about the loan amount. PPP loans are going to be capped at $10 million, with the loan amount being the lesser of 2.5 times the average monthly payroll that's incurred over the 1-year period immediately prior to the loan. Note in the slide there that payroll costs exclude annual compensation in excess of $100,000. So everyone's comp is going to be capped at $100,000 for the purpose of determining the loan amount here. So as mentioned earlier, there has been some initial guidance that's been provided from the SBA. The terms of the loans are going to be the same for everyone as it relates to the interest rate of 0.5%. As it relates to the term, there'll be a 2-year maximum term. And all payments can be deferred for a period of 6 months. As expected, the loans come with certain restrictions, such as no stock buybacks, no dividends, no forgiveness, other than what we'll talk about in a couple of slides, and no large layoffs. So as you can see, this is a really streamlined process. I'm sure many of you have seen the loan application form that's been circulating from the SBA. The idea here is to make this as easy as possible for folks to be able to submit a loan application form. Of course, there's some supporting documentation that you'll need to prepare in order to fill out the form, which we'll get to in a few slides here. So loan amount and payroll costs. So for the purpose of determining your loan amount with respect to employees, payroll costs are broadly defined and are going to include each of the following items listed here. So let's kind of walk through each of them. Salaries, wages, commissions, and other similar compensation. For your gig workers, cash tips and their equivalent are going to be included. An important one here, severance is included, both as it relates to the loan amount and forgiveness on the other side. Group healthcare benefits, including insurance premiums, are going to be included. Leave and retired benefits are included, and there's certain other expenses like state and local payroll tax or certain state and local taxes on employee compensation that is also included in that payroll cost figure, which will ultimately determine your loan amount. Some important exclusions to keep in mind. We spoke about compensation in excess of $100,000 on the previous slide. That's an important one to keep in mind. For our folks that are north of the border, employees outside of the United States cannot be included in the analysis of a U.S. business and their payroll costs. And any amounts that are otherwise recovered under the Families First Coronavirus Response Act, those are also excluded from the calculation of payroll costs for the purpose of determining your loan amount.
Jonathan,
Okay.
one point of clarification here for the benefit of the audience, just to make sure that we're on the same page. If you can go back to the prior slide. In terms of the exclusions that Jonathan referred to, compensation of in excess of 100K, just want to make sure that people understand this is a marginal analysis. In other words, if you have an employee that's paid $150,000 a year, the first $100,000 is permissible to be included in payroll costs. It's simply the marginal excess of 50 that would be excluded for purposes of that calculation.
That's right. Thanks, Shannon. Okay, so use of proceeds. What can the loan amount be used for? What can the loan proceeds be used for? Again, a list here to kind of go through. Certainly salaries, commissions, and other payroll administrative costs, healthcare, mortgage interest payments, rent lease payments, utilities, and interest on any other debt, prior to February 15th, 2020. I think the key point here is that we've been suggesting to people is that, the idea here is that the loan proceeds are used to, satisfy the operational costs necessary to operate your business that otherwise would have been met if not for the shutdown. So I think that, operating your company in the ordinary course before, that's kind of what you want to be addressing here with the use of these proceeds. One of the key provisions of this act and this program, is the element of forgiveness, which I'm going to turn it over to Shannon in a moment to talk about. But before I do, note that, the way this works, the PPP loan, when paired with the 8-week loan forgiveness program of the payroll cost, will effectively serve as a federal grant for eligible businesses to keep employees employed, or provide the ability for those businesses to rehire employees that were recently laid off. And the idea here being that this will hopefully, provide a lot of relief to businesses in the short term. And any amounts that are not forgiven through the process that Shannon will speak to in a moment will be treated as a loan under the PPP loan. So with that, I'll turn it over to Shannon on loan forgiveness.
Okay, thanks, Jonathan. So we'll quickly review this, and then I just want to talk about the practical application and how business owners and investors should be viewing this concept of loan forgiveness. So at a high level, you apply for and receive a loan under the PPP. It's equal to about 2.5 times your monthly payroll costs, which include compensation, but some other factors that were previously discussed. Gives you 2.5 months worth of operating cash that can be used for payroll and other operational items. You've got the half interest annualized interest rate. You've got a 2-year term. And so effectively, this is as close to free money from a cost perspective as you can get in the marketplace. That 2.5 times factor can effectively be increased through this forgiveness concept. The way the forgiveness concept works is if you retain and or rehire recently laid off workers and you maintain them in their status for the first 8-week period, commencing with the loan date, you will qualify for that 8-week period or 2 months of loan forgiveness, and it will not be treated as gross income for tax purposes. So if I'm operating a business, I submit the application tomorrow, It takes a few weeks for the application to be approved, but for sake of argument, let's say middle of April, April 15th, I receive, a $2.5 million loan. I keep my workforce intact from April 15th through June 15th, or I hire back some recently terminated employees. And then I operate the business as best as I can, utilizing those funds and whatever other resources I have to get through the crisis. You have the ability through your lender to seek forgiveness of the first 2 months of payments during the 2-year term of the loan. So $2.5 million divided by 24 payment periods will indicate, your monthly payment. I'm factoring out interest at this point just to keep it simple. But the way to think about that is you basically would have about $105,000 payment per month. And if you were to qualify for the forgiveness, that effectively gives you $210,000 of forgivable principal and interest under the program. So within the context of that example, meaningful and helpful, but the key to the underlying concept of forgiveness is that you retain your workforce and or rehire as needed to get to where you were historically before layoffs during the crisis, and you maintain it for the first 8 weeks of the program. Thereafter, the determination is made by the bank. The forgiveness will be factored into your repayment schedule, and you'll have accomplished your objective. So that's where the federal grant concept comes into play that Jonathan had alluded to previously. The other way that I would view this loan forgiveness program operationally is if you qualify for a loan with the PPP, you're getting 2.5 times your monthly costs in payroll. And then if your ability to qualify for the forgiveness occurs, effectively the overall amount that you're receiving is, from an operational standpoint, 2.75. And so, the way to look at it at a high macro level is there is almost a quarter's worth of operational capital that could be accessible through the program, assuming that you qualify. So with that, we'll go on to the next slide. In terms of any potential negative adjustments related to forgiveness, the big point here is simply you're going to have a baseline headcount for your employees, and that'll be either what you currently have, assuming you have not initiated any layoffs, or what you previously had before layoffs were initiated as a result of the crisis. So from a chronological standpoint, we're really talking about whatever your employee headcount was within the last 4 to 6 weeks. So basically the end of February, beginning of March timeframe forward, and or now, if there were no layoffs. And that's the baseline headcount that you're going to be looking at. What you cannot do under the PPP and still be eligible for forgiveness is apply for a loan, receive the funds, and then 4 weeks into the first 8 after the loan's been granted, you begin to have layoffs, terminations, things of that nature, furloughs, and then seek forgiveness. There's a recapture concept under the statute that basically will recapture whatever percentage of the first 8 weeks of forgiveness that you're seeking as a result of any subsequent terminations that you will have initiated during that 8-week period. So there's no gaming of the system, but there's a good faith certification as you seek the forgiveness that you have maintained the employee workspace to what it historically was. If it were to come to light afterwards that you had not done so, then you would be at risk of a recapture and or penalties. But that's how the loan forgiveness program works at a high level, and it's another way for this program to effectively and hopefully give each of these companies some level of stimulus from a cash perspective to directly impact the operation of their business. Next slide for you, Jonathan. Actually, I apologize. It's not Jonathan.
No, it's okay.
It's Natalie.
We'll have Natalie.
Exactly.
Yep.
Thanks, Shannon. Thanks, Jonathan. So the CARES Act allocates $250 billion in federal funds to the states for unemployment benefits. This funding significantly expands state employment benefit schemes across the country in three major ways. First, the Act relaxes eligibility criteria. Second, it extends the duration of benefits. And third, it increases the benefit amount that individuals will be eligible to receive. So when a state signs on to participate in the Pandemic Unemployment Assistance Program, the categories of workers eligible for unemployment benefits will expand. Notably, self-employed workers, gig workers, independent contractors, and those with insufficient work history who otherwise likely would not qualify are now eligible if they have lost their job because of COVID-19. So the duration of unemployment benefits varies by state. In Massachusetts, unemployment benefits typically last up to 26 weeks, which is consistent with most other states' unemployment programs. Now, under the Act, the duration of unemployment benefits can run for up to 39 weeks, taken any time between January 27th through December 31st of this year. Notably, the federal government has provided funding to incentivize states to waive the common 1-week waiting period, which will allow people to receive their benefits sooner than they otherwise would. So essentially, where a state agrees to waive the 1-week waiting period, the federal government will cover the cost of that first week. Additionally, pandemic unemployment benefits allow anyone collecting unemployment to receive an additional $600 supplement per week on top of whatever the individual typically qualifies for with regard to their state benefits. This additional benefit lasts for 4 months, beginning in April and ending in July. So just to illustrate this principle, using Massachusetts as an example, here, unemployment benefits are usually about 50% of a person's regular pay per week. The statutory maximum is $823 per week. So this is roughly what someone making about $85,000 annually would receive. So an individual who makes $85,000 or more per year will receive up to $1,423 per week until July 31st, 2020. And that figure represents the $823 Massachusetts benefit plus the new $600 federal supplement. And the goal of this flat fee payment is to allow the average worker to receive as close to 100% of their regular rate of pay as possible. But of course, with this supplement, some workers will ultimately receive benefits that exceed their regular rate of pay. So for example, an individual in Massachusetts making $50,000 per year is now eligible to receive $1,080 per week. That is the Massachusetts payment of $480 per week plus the $600 federal supplement. Whereas if that employee were still working, the normal rate of pay would be $961 per week. So there's just now a difference there with respect to certain workers. And just as a final logistical note, the $600 weekly federal payment is payable by the state to the individual and will be reimbursed by the federal government. It will not be charged to the employer's unemployment insurance account. So now I'm going to turn it back over to Shannon to speak about some action items that companies should be taking now if they are not already.
Thanks, Natalie. Appreciate that. One follow-up point in terms of what Natalie had covered and how business owners might be thinking about this. The underlying point here is twofold. One, the program is intended to help give stimulus to companies, cash to companies to continue operations. Part of that program the aspect of the PPP is the loan forgiveness we talked about in the previous few slides. But There is also, to the extent that it's required by companies to continue layoffs or initiate layoffs, a more favorable unemployment environment generally. And the point of Natalie's summary there is to empower business owners to understand that the benefits that are available for potentially terminated employees are not insignificant relative to what they have been historically. And from a PPP perspective, even if you were to initiate terminations, the major negative aspect of doing so is the forgiveness period and the recapture rules that are subject to that. You can still apply for the PPP, receive the loan, and have some form of layoffs, and you may have to do a cost-benefit analysis to understand that. But it's helpful, we believe, based on the slide that was just presented by Natalie, to understand that employees that were adversely affected by that decision can immediately apply without a waiting period for the benefits that she described. These are difficult times, difficult choices, but they're not mutually exclusive situations. So we hope that that information will help empower you too in terms of how you think about the ultimate welfare of your employees as you make some of these difficult decisions. So bringing this full circle in terms of how you ought to be thinking about what to do next. And before I get into these specific steps, I apologize for not announcing it up front. To the extent that you have questions, there's a chat box to the right of the presentation. You can submit those, type those in, submit those, and we will allocate some time at the end of the presentation to address those questions. We've already received a handful, but to the extent that you have more and they're not repetitive, we will address those. So what to do today? As we indicated, tomorrow is the start date for the application process. You need to run, not walk, to your SBA authorized lender and or contact them immediately. One of the questions we've received repeatedly is, my lender is not an SBA authorized lender, what should I do? The short answer is you need to still go talk to your lender, and you have to have your lender hopefully use some of their political capital to connect you with someone that they know within the banking system that is an authorized lender. The point being, if it's your lender and you have a long history with them, but they're not an SBA lender, leverage that relationship to get them to put you at the top of the pile with one of their referrals who is authorized to deal with the SBA so that you don't get behind a long queue. That would be the first recommendation. Second recommendation is if you work with a lender who is authorized, then you need to obtain the online application. You need to fill that out quickly and as best as you can, and we'll go through what materials are required to be submitted with the application on our next slide. But you need to process that. You need to communicate, in our judgment, verbally with your authorized SBA lender so that they know it will be forthcoming. And you need to leverage as best as you can the power of your relationship with that banker, because that banker is going to be inundated probably in a way that they've never been inundated before under this program based on the demand. The key to all of this is getting in the queue as quickly and as efficiently as you can. So to the extent that you either don't have a relationship with an authorized SBA lender, leverage your relationship with your existing commercial lender to make a connection. If neither one of those options exists, go to your professional service provider, your accountant, your lawyer, your financial advisor, see if they have relationships with authorized lenders that they can leverage for your benefit, and make a connection with you, and make that connection yesterday. You can't do it soon enough. And then 3, frankly, you have to be persistent. Don't allow the numbers to discourage you. If you're not getting responses back from any of those previously mentioned sources for potential introductions or contacts, just keep at it. Maybe divide and conquer within your organization and have multiple people reaching out to multiple parties until you actually are in contact with the appropriate SBA authorized lender. And then just push, 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 and stay on top of it once the application has been made. Leverage the relationship so that the squeaky wheel is getting the grease, for lack of a better phrase. I'll turn it back over to Jonathan.
Thanks, Shannon. So one of the things at the conclusion of this webinar, one of the things that we will circulate to all of the listeners is a number of materials, or a link to a number of the materials, which will include the loan application, some frequently asked questions, among other materials that will help you through this process. You know, the borrow information that's required to complete the application, it is limited. This is a 2 or 3 page application form, with some instructions. As it relates to your determination of payroll costs, a worksheet demonstrating that the PP loan does not exceed the maximum limit, and that you're applying for 2.5 times monthly payroll. Those things we would recommend that you have in hand, as those will or may be requested at some point in connection with this process. And frankly, they need to be prepared in order to complete the application form. So all of those materials, it's a limited number of things that companies need to prepare to complete the application, but we recommend that you have those on hand to the extent that they're requested. Obviously, a 19 profit and loss statement would be ideal to have in hand also, but understanding where we are in the calendar year, for a lot of folks that may not be available at this time. So those 4 bullets there on this screen really are the items to really focus on, that will enable businesses to complete the loan application form that has been provided by the SBA. And again, just to be clear, information will be provided to you, including, I believe, a recording of this webinar that will put everything you need into one place. So with that, what we're going to talk about next is just some other emergency funding solutions that are available and out there for similarly sized companies and for companies that are in excess of the 500 employee limit. So I'll turn it over to Shannon for that.
Thanks, Jonathan. So a couple of quick mentions here. So we focused on the CARES Act and the PPP. Our recommendation is that's the quickest and most liquid form of capital that's currently available under the emergency funding system that the feds have put into place. So proceed post haste to obtain that type of loan. But to the extent that you either don't qualify or are rejected, there is something called EIDL, EIDL, the EIDL program. It's also administered by the SBA, and it was authorized under the COVID-19 related economic injury disaster loan program. Think of this as effectively a mortgage. Some basic terms: 30-year term, collateralized by real estate, maximum value loan amount of $2 million. So not insignificant, not unhelpful to you, but it could take longer in terms of underwriting. It could take longer in terms of loan application process, et cetera, but it is a program that's out there. It is subject to the same 500 employee limit, so be mindful of that. But to the extent that you have advisors who can work with you, they can shed more light on this program. Moreover, as Jonathan had previously mentioned, we do have advisories that Nutter has put together here. He and I, in particular, with a few others, have authored them, and there are some bullet point summaries there that will help you better understand that program. Shifting gears to the second bullet point, and this is for those enterprises, those businesses that ultimately, no matter how they try to shape and contort and get under that 500 employee limit, just cannot do so, and it's not a defensible position, and therefore not eligible for either EIDL or the PPP. There was also included in the CARES Act authorization for additional programs that are applicable for companies that are larger than 500 employees. The 3 bullet points below outline what those programs are. There's what's commonly referred to as 13-3 programs and facilities. These are programs that are similar to what was enacted during the 08-09 financial crisis. There's also a Main Street lending program, and then a mid-sized business program. The way to think about these three programs is as follows. The CARES Act authorizes the government, the Treasury, to put into place different aspects of these three programs for the larger sized enterprises. As we understand it, that is ongoing as we speak, and it should be forthcoming here in the next week or two. It's not lost on the feds and the regulators that not all applicants will fall under that 500 employee limit, and therefore there's a whole subsection of the economy that should be eligible for similar type of assistance, albeit under different programs. So as you are interacting with advisors and within your companies to determine what programs are applicable to you, if you don't technically qualify as a small business, this is the way to refer to those programs. And if you mention a 13-3 program or Main Street Lending or even the mid-sized business program, your advisors that deal with you on a regular basis and are familiar with the regulations that have existed in the past under this type of legislation should be able to point you in the right direction and should be able to assist you on that application process. And I think that wraps up in terms of the actual formal presentation. So we're going to shift to questions. Jonathan, Natalie, and I will take those topically, and I will moderate that. But to the extent that you have questions as we are dedicating the last 8 to 10 minutes here to this process, please feel free to submit those via the chat room. The first question that we have here is, do employer payroll costs include commission payments to 1099 advisors in the financial services industry? The short answer here, absent any significant regulatory interpretation, but based on what the statute says, is yes, payroll costs do include 1099 compensation. The statute is not specific, nor does it disqualify certain industries. And so our recommendation for purposes of this question is proceed as if it does, and include that for purposes of your loan calculation amount. The next question is pertinent to the loan forgiveness period. It says, for the loan forgiveness, does the 8-week period start at loan date or when the employer is allowed to reopen, such as retail stores in the closed mall? This is both an excellent question and representative of this existential crisis that we find ourselves in. The short answer, the technical answer to this is it begins on the loan date. However, the caveat that the questioner included here obviously is problematic because of the lockdowns that have occurred. Thinking out loud with you in real time, our recommendation would be as follows. Assume it's on the loan date and apply for the loan, factor that into your analysis. If it ends up being just on the loan date and that somehow adversely affects you because your operations don't open until a later period of time, from a conservative standpoint, you'll know what the worst result is from a forgiveness standpoint. You may lose some or all of that period of time and the benefit of that. However, you have until June 30th of 2020 to seek loan forgiveness. And so in our judgment, there will be a number of scenarios such as what has been identified here that will pop up. And either the SBA or SBA authorized lenders will have some history or experience with how to deal with these different situations. And it may be that by June 30th or even into July, when the determination is being made about the eligibility for forgiveness, there may be some type of retroactive loosening or waiver of the start date for purposes of forgiveness, and perhaps they'll correlate it to when the business actually opened up. There's going to have to be some judgment by both the SBA and the lenders as to how to correlate the facts on the ground with the intention of the statute. And this example here, I think, is a prime example of where there may be a disconnect between those two principles, and there may be subsequent resolution. But from a conservative standpoint, and based on what the statute says, the loan forgiveness period of 8 weeks commences on the loan date. The next question is, for SBA forgiveness, are there any limitations associated with revenue? More specifically, if some revenue continues to come in, will that be factored in? Will that be factored in, or is forgiveness completely and exclusively Sorry, I'm dealing with some technical issues here, but I'm reading it in real time. Forgiveness completely and exclusively driven by incurred costs. Jonathan, feel free to jump in on this one as well, but my take on this is that the loan forgiveness is for the 8-week period commencing on the loan date, and there's no mention, to my knowledge, anywhere in the statute, and certainly there have not been any regulations forthcoming that have somehow indicated that revenue increases or the occurrence of any revenue somehow negates the ability to seek forgiveness. Is that your opinion as well?
That's right.
Okay.
Yep.
Next question. How are the wages for self-employed going to be calculated? Without the benefit of additional insights here, I think the way to view it is look at your tax return, and however you characterize your wages for purposes of your federal tax filing, that's how you ought to be interpreting your loan application amount.
Agreed with that also.
Next question, regarding the forgiveness calculation, if we have more employees than the base period, is this beneficial to the calculation? It is, and Jonathan, what I cannot recall is if you're allowed to actually exceed by 100% the amount for that loan forgiveness period of 8 weeks or not. Do you happen to know the answer to that one?
I don't have that offhand, but just thinking about this example in real time, I think as it relates to the forgiveness amount of the loan, the full amount would be forgiven. I'm not sure that, there's a provision for anything further by virtue of having your employee base increased.
Expand, right. So I tend to agree with that as well, but for purposes of the questioner, we will do some follow-up on that, and we will notify the group to the extent that we can track down the answer to that. Natalie, there's another question now that's on the employment side, and it says, for the unemployment piece, can people who filed claims in 2019, prior to COVID, get the extended benefits, the extra 13 weeks, and/or extra $600?
Thanks, Shannon. So the answer will probably depend here on the reason for termination or separation from employment. If the employee lost their job due to COVID-19, that's what these benefits are intended to capture. And that sort of extends back to January 27th, 2020. So likely no. There might be, again, it's tied to whether the employee lost their job due to COVID-19. So there might be situations where there was, post January 27th, 2020, there was a layoff or termination, but before the act went into place, that might be captured. But for someone who filed in 2019, likely not.
Thanks, Natalie. One important point, too, for purposes of loan forgiveness, shifting somewhat from the unemployment question, you have until June 30th for a catch-up period. So, for example, you could apply for the PPP, receive it, hypothetically, April 15th, the loan. You could then have subsequent layoffs. You could operate the business for the remainder of April and the month of May, and then beginning into June. If things were to improve, and then you were able to rehire employees such that your headcount ended up at least at the same level it was when you received the loan, that additional rehiring will allow you to avoid any of the recapture penalties so long as it occurs before June 30th. Moreover, you do not have to necessarily rehire the same individuals that were terminated. It's an employee headcount analysis as opposed to an individual analysis. And there's lots of ways that could play out. You might terminate someone in the interim period, and then they are no longer available to be rehired. That would be a first world problem to have in light of the circumstances here. But you could certainly replace or fill that position, and for purposes of loan forgiveness, be back to where you needed to be by way of employee headcount. The next question is there one application or is there one specific for PPP? Jonathan, I know you've taken a look at a few of the pieces that have come out of the SBA. Do you want to address that one?
There is one application, and we will circulate it to this group at the conclusion of the webinar.
Okay, the next question. Can you do both an application for PPP and EIDL? The short answer is yes, but part of the certification program for the PPP, not certification, but part of the rationale for the PPP is that to the extent that you have received funding from other sources under the SBA, those would be offset against the amount for which you were deemed eligible under the PPP. So there really is no way to double dip. You certainly can apply for both. In our judgment, it would take longer to go through the underwriting process for EIDL versus the PPP. But hypothetically, if you were to apply for both and qualify for both, there's going to be a netting out of one against the other so that the aggregate amount that you can borrow from the SBA under these circumstances will be limited to what otherwise would have been had you just applied for the PPP.
And Shannon,
last question.
One further point on that. EIDL came first before the PPP program. So in some cases, folks had secured loans through EIDL before this program. Folks were aware of the PPP loan program. So if you've done that, that shouldn't stop you from pursuing relief under the PPP. And like Shannon said, there'll be no double dipping, and it'll just be netted out. So just wanted to add that.
Appreciate that, Jonathan. Okay, we're running up against the clock here, so I want to be respectful of people's time. To the extent that there were certain questions that were asked that we were not able to get to, feel free to email the presenters here, and we will do our best to respond in real time. Moreover, look for a follow-up of the recording of the webinar, and look for a follow-up in terms of either links to published materials or the actual materials themselves for purposes of what was discussed on today's program. I want to thank both Jonathan and Natalie for supporting me and participating with me on this program. I want to thank everyone that attended. We appreciate the difficult circumstances that everyone's in. We're hopeful that the information that was presented moved the ball further down the field for you in terms of how to think about the PPP and some of the other programs. And we are here as a resource if and when you have questions about this or other issues. With that, I will end the webinar and wish everyone a good day for your business. Take care.